My name is Randy Miller, and I have the pleasure of addressing you today with respect to some of my comments for the California Young Lawyers Association, and it's my privilege and honor to do so. I am a 30-plus year lawyer and happen to be affiliated with the Committee on Professional Liability Insurance as part of the State Bar program and have been its chair for the last 3 years. And I chose a topic that I thought would be helpful to newer lawyers practicing in California. And today I want to talk about your behavior. And when I talk about your behavior, it's not with your family, it's not with your dog, it's not in the gym, it's not on the golf course, it's interacting with other lawyers on your matters. And it could be anything from civil litigation to transactional work to a criminal practice. It doesn't matter. Somehow along the lines, lawyers got the impression that they were supposed to be the warrior lawyer and that everything counts in their advocacy on behalf of their clients. That's actually the public perception that we see perpetuated in media and TV. And while there might be some truth to that, it isn't always the right way to go, and the line can be crossed. And that's what I want to talk about today is lawyer civility, or perhaps the better way to put it would be lawyer incivility, and actually name this Breaking Bad, the implications of lawyer incivility. There's been sort of a tepid reaction by bar associations to sort of reel in lawyers whose behavior crosses the line. There now is an oath that young lawyers take after being licensed in California regarding their obligation to remain civil and dignified at all times. Remains to be seen how that's going to be played out, what sort of implications it'll have on perhaps reeling in lawyers' conduct. There are several county bar associations that have come up with rules that are actually quite wonderful and quite effective with respect to the types of civility that they expect lawyers in that bar to follow, dealing with things like extensions and returning phone calls and those normal types of courtesies that are out there. Other than that, it's not a highly regulated area of the law, so for some lawyers, they look at it as an opportunity to exploit. Some of these cases get a lot of press, lawyers confronting each other in court or on the street or in depositions, but it doesn't necessarily have to be in public. It could be in correspondence, it could be in telephone calls, it could really be in any setting. The purpose of my remarks here today are to attempt to sort of set a tone and perhaps even set a line to be drawn with respect to what is courteous and dignified and civil conduct between adversaries in a matter and what is not. There are many implications to lawyer incivility, and they range from everything about implications in the case to implications to your client, to implications to expenses that are incurred in the case, and actually for future liability of the lawyer who crosses the line. And I want to just go through these one by one and share with you, with my 30 years of experience, what I've seen and more recently what I've read when these cases get to the point where they become publicized. So here's a few of the implications that you can have when a lawyer's conduct, whatever that might be, hostility, confrontation, assault, bad language, profanity, just a lack of dignity, a lack of respect, and a lack of trading courtesies in a case. One is that you can have court sanctions. And if you're a civil litigator, you know that there are lots of opportunities to interact with opposing counsel in cases. A lot of this comes during the course of discovery, comes in the course of law in motion regarding discovery, and depositions is really sort of a prime arena for lawyer pugilism. And so it's in that setting that if these matters are eventually brought to a court's attention, they can result in court sanctions. Discovery motions, a court always has the ability to assess sanctions if it feels as though counsel's actions were not in good faith, and I've seen plenty of examples where motions are brought before the court with respect to answers in a deposition, and the court will look at the transcript and figure out that one lawyer was perhaps taking an unreasonable position, even a hostile position. There was a case reported recently in a law firm I'll leave out, but it's a matter of a public record, of a lawyer actually confronting another lawyer during the course of a deposition, wagging a finger in his face, calling him names, profanity, and I think there was actually a slap to the face, so it actually potentially constituted assault. That lawyer was sued, and the court ultimately felt that it wasn't the sort of irrational, unreasonable behavior that would provide the basis for a civil assault charge. Perhaps that's sort of a testament to where the line should be. So number one is court sanctions, and that can be costly to you. It's not something that you can pass ethically on to your client, so that's a check that you or your firm will have to write if your behavior crosses the line there. State bar referrals, number two, it's another implication to bad behavior. If an opposing lawyer, or frankly a client or a member of the public or a judge, feel as though the conduct of a lawyer was unethical, or was too aggressive, or was discourteous, or just happened to not display the normal amount of integrity, you can be reported to the state bar, and the state bar can investigate and possibly subject you to discipline down the road. That's obviously a very serious consequence, and it goes on your public record, and anybody who wants to look it up on the state bar website can find that you had prior state bar disciplinary actions. Civil liability, what I just discussed was a case that happened to make its way into the system where one lawyer sued another lawyer for assault. So it can actually get to that point. That's expensive. I presume that if you're working for a law firm that is employing you, they will be none too happy that you've put yourself and the firm in that position. It could also it also can amount to poor relationships with opposing counsel. Obviously, to the extent that this behavior is between two lawyers, it's just going to create a pall over the case, and it's going to certainly affect your ability to work rationally and capably and productively with the other lawyer. You're not doing your clients any favors by casting that sort of attitude on a case, because you're not going to be able to settle the case likely if you can't agree on how to relate to each other. It might also relate to client expenses, because it becomes more expensive in a case where it's very heated and there's a lot of unnecessary work then it's done, and you might find yourself with an upset client. Number five is the impact on a subsequent legal malpractice case. If the case turns out poorly, you might end up being sued by your client. Well, who do you think is perhaps your best witness in the case in support of the work you did? Would be the opposing lawyer. The opposing lawyer is a built-in percipient witness. If you have a great relationship with that lawyer is more apt to come to your rescue in a legal malpractice case, testify on your behalf that you were competent, that you were efficient, and then you approach the case with the right amount of advocacy. Number six is your conduct could also impact a subsequent malicious prosecution case. If you are sued by the opposing party because you instigated a case without probable cause, your conduct, I guarantee you, is going to be Exhibit A. If you write a nasty letter, that could be evidence of malice in a malicious prosecution case that is otherwise a very difficult element to prove, but you hand them a gift when you write a nasty letter because it's evidence, or at least some evidence, of malice. It could impact your reputation and your business. It could impact your marketability and your productivity. Number nine, frankly, it could impact your job satisfaction and your mental health and other aspects of your life. If you are that tightly wound that you can't control yourself civilly in that sort of arena, then I suspect there probably is deeper problems. And what I wrote last, and I took this from the movie Caddyshack, is that on your deathbed, you will not receive total consciousness as a result of your hostile behavior in a case. So my closing remarks are: be strident, be intelligent, be a zealous advocate on your client at all times, but you can do so in a way that is honorable, done with integrity, done in a dignified and a civil way. And if you adopt those rules, you're going to have a very successful career.